Solicitor is in charge on this side.
Allow me, my lord, before Mr. Sybil responds, allow me to.
Of course, I'm only telling Mr. Judge that you are in charge on your side. So let
Lord,
one
kindly
person.
see, my lord, page 6.
All right.
I'll not read everything.
And
Page
then we'll
6.
immediately come back to Mr. Sybil.
Page 6, my lord.
Don't read it. Just let's.
Para 2. I'll not read, my lord. Para 2. My lord, the first thing which was yesterday, my lord, highlighted was in the assembly. Para 2. This is in Kupwara in a public rally. My learned friend has an objection of it being televised. He said this in a public rally. Then, please see 4. 18th March 2019. My lord, before the presidential proclamation. Then 5. Lord, 5 may look innocuous, but I'll show, my lord, how it is not. Lord, 5, Lord, whenever terrorist attacks takes place, the terrorist is killed, the civilian is casualty, and the security forces are killed. The sympathy is only for terrorists and the civilians. Please come to page 8 directly. Lord, only as per report in Greater Kashmir and thereafter the later part. Then kindly come to, my lord, page 11, my lords, which is more serious, my lord, in my personal view, my lord, subject to your lordship's, my lord, accepting that. This is 19th March 2015. Please read, my lord, 1. Then please read 3. 3 is, my lord, very, very serious. It's not just Zindabad. It is again 15th of September 2019. Then 4.
Yes, we've seen it.
My lord, 4 middle.
Yes.
My lord, 4 at the bottom.
We've seen it. We've seen it.
India is referred to as if it's a foreign country.
All right. Yes. Yeah. Yes, Mr. Sybil.
Lord, therefore, I was insisting
Please allow
yesterday
me now, sir.
that his affidavit must say that I withdraw these statements. I do not support terrorism. I do not support any separatist activity, and no citizen in this country can logically
We must have a
any
uniform
objection
affidavit for
to
every
filing.
citizen to file this, Malats.
Can I just
In
say
this
something,
court.
Manoj? That point 3 at page 6, they say pushing a separatist agenda. Filing a 370 petition in this court is pushing a separatist
I'm
agenda.
sorry.
I have a very strong objection to the government of India taking this.
I am
step here.
sorry.
All of us are pushing a separatist agenda by being.
Please.
One second. One second.
No, I'll clarify.
One second.
Malad,
I haven't.
Mr. Solicitor, please wait for a second. Mr. Shankaran, I think this is unfortunate. Nobody can say that because a petition under 32 has been filed, up to this point, nobody has said that the filing of a petition constitutes separatist agenda.
I have said.
We have.
What are you saying there?
Bro, why this date is mentioned
One
even
second.
after filing years.
The access, one second, access to our court for ventilating grievances of citizens within the framework of the Constitution is a constitutional right in itself. Anyone who accesses justice under Article 32 cannot be turned out on the ground that you are following this agenda or that agenda. On merits, which way any individual petition goes is for the court to separate the grain from the chaff.
May I clarify?
But I don't think,
have
we have not, Mr. Shankaran, we have not heard the government.
Saying this about us.
We have not
Only
heard
a
either.
minute, Mr.
One second,
Shankaran.
Mr. Solicitor, 1 second. We'll put a lid on this now. Otherwise, this will go on endlessly.
Only give me.
1 second. We have not heard either the Attorney General of India, who is leading arguments for the Union of India, the Solicitor General, who has shouldered a large part of the burden, say that these petitions should be dismissed on the ground that they are separatist agenda. They have argued the matter on merits. It has been argued on constitutional terms. We have indicated that that's how we are going to resolve this issue. And I don't think that's been the main plank of either the solicitor, the attorney, or anybody who else who follows.
That's all I'm.
Sometimes when individuals as interveners come before the court, we also as judges understand that there is an anguish which was expressed,
Is not the interview.
and that anguish which many of the interveners have expressed, we as judges know how to deal with that.
Give me a minute more. Give me a minute more. The date for 18th March is mentioned that petition is filed. to show that even subsequent to the filing of the petition in May to 2018, etc., my lord, this continued.
Mr. Solicitor, you have made,
Filing of a petition
Mr.
is
Solicitor,
not as essential.
you have made your point. You have made your point, Mr. Solicitor. Mr.
Yes.
Sibal.
Well, I hope that sentiment applies to us also, because we have not made any submission other than on the law and the constitution. Just as the other side has done it, Mullah, at least we have not made any submission outside of that, Mullah. And we want to carry on this debate, Mullah, through the constitution, not through processes of this nature. Anyway, Mullah. Now, Mullah, yesterday your lordships asked me a question about merger, how many mergers have taken place. Kindly come to volume 4.
Mullah, I leave it to the court. Mullah, I
Mr. Judge, please don't interrupt. There's a limit to it.
There is a boundary.
Yes.
Mullah, it's volume 4.
Just 1 second, Mr. Sibal.
That's another 20 minutes gone.
Mr. Sibal, is your client, has he filed an affidavit pursuant to what?
He is going to file, he is going to reach by 12 o'clock.
Yes, now on merits, Mr.
Yes.
Sibal.
So, Mullah, volume documents, volume 4, PDF 303.
Volume 4.
Yes, PDF 303, Mullah. This is in the white paper, Mullah.
303?
303. Mullah, this has taken 20 minutes. Yesterday, half an hour. The lordships had given us from Monday, Mullah, onwards, morning, Mullah. How do we finish?
This is the white paper. That is
White paper. Now, let's kindly see appendix, statement showing area and population of states which have merged with the provinces.
I'm sorry, which page are you referring?
Page 303, PDF 303.
PDF 303 in volume number 3.
In volume number 4, document volume 4. It's very important, Mullah. So this is, as I told your lordships, all the states who joined the provinces. And then they were merged, provinces which merged. So they first joined the provinces and the provinces merged. And you have 21 such mergers. And the dates of the agreements are on the left side. 1148, 1148, 1248. This is after Mullah's January 20, before January 26, 1950. This is important. This didn't happen with as far as J&K is concerned. Now, this is now one part. Now, kindly come to the next table. That is statement showing area and population of states constituting central administered areas, which were the chief commissioners' provinces. Now, you see here, there's no question of any Mullad's merger. No question of any merger. It was directly administered. And but through merger agreements.
now these, just for a factual clarification, these centrally administered areas, what was their status under the Government of India Act? Were they were treated as chief commissioners' provinces, and they become centrally administered areas
Yeah,
after.
correct. Now come to the third. These were princely states, Mullah, which actually went to the unions. These are princely states, Malad, many of them. Kindly see, Malad. Manipur, Tripura, Bilaspur, Kutch, Haroch, Chamba, Mandi. These are all Raja of Mandi. These are all princely states that merged into the Chief Commissioner's provinces, which are termed as Chief Commissioner, directly administered. Statehood.
Then the third statement is those which constituted unions.
That's right.
So
Now
they
these,
formed a union of more than one of the.
correct. Now this is important, Mullahs. Kindly see how the merger agreements here, only 5. Now you'll see, Mullahs, item 1, 22 units, as I told your lordships yesterday, in Saurashtra. Then, Mullahs, Jodhpur, Jaipur. This was called originally Rajputana, which included all these. Then you have 15,648, Madhya Bharat. Your lordship sees that? Madhya Bharat. Then 2848 Patiala, East Punjab, Union, Travan, and then Travancore, Cochin. This is 552. Total 275, grand total 552. So you have therefore the Chief Commissioner's provinces. You had the province, princes merging into the provinces, and you had these 5 states. All through merger agreements. No exception, except Jammu and Kashmir. Because that was not conceived in terms of 370 itself. Now kindly come to 373, Mullahs. This is also important. PDF 373. 3. Now what in these 5 provinces called the Union of States, what were the kind of notifications issued, Mullahs? What were the kind of proclamations issued? Your lordships will find at 373 onwards.
So this 552 was an addition of 216 plus 61 plus 275.
Correct.
Yes.
Correct, Mullahs. So now if your lordship comes to PDF 373. Now, you see that Raj Pramukh of Union of Patiala, East Punjab states, Saurashtra, Travancore, Rajasthan, Madhya Bharat, rulers of Hyderabad, Mysore, Jammu, Kashmir are published. This is the proclamation. What does the proclamation say? Last paragraph, I now hereby declare. Your lordship has that? My lords have that? It says, I hereby declare that the Constitution of India shortly to be adopted by the Constituent Assembly shall be the Constitution for Patiala, East Punjab, as well as other parts of India, and shall be enforced as such. Come to the next one, Mullahs. Each of them, Mullahs, had the same proclamation. Each of them. And all that happened prior to 1950. Except Jammu and Kashmir. And you'll find that at 379, Mullahs.
Sybil,
And see if you...
Mr. Sybil, do you think it would have been a unilateral action or it was?
Sorry, I can't hear you.
It was an action on its own, or it was something which was the government of India at that time ensured that it happened? Obviously, the government of
Obviously,
India ensured that it happened.
there was no question on its own, Mullahs. It would never happen like that. Some of them couldn't exist independently.
So, we have understood your argument on that. Can we move on?
Now, let's look at PDF 379, because all those proclamations are different from the proclamation Kwe Jammu Kashmir, which is 25th November 1950, before the 26th January 1949.
The proclamations is the firman of the Nizam as well. The Nizam you find at page 377,
Yeah, but the
23rd of November
but the language is
1949.
different.
This was certainly not voluntary.
Of course not. Of course not, Malaj. I agree. This is what I responded to my lord. But Malaj, the language is different from Jammu and Kashmir.
So keeping you probably in J&K, keeping at that time the political environment, it was something different. Was something different.
That's all that I'm saying, Malaj.
That's
My
argument we have understood that argument.
Yes, and therefore it was incorporated in these terms in the Constitution, which was not done by anybody else, which only shows to you that merger was never contemplated except in terms of 370. All the others became merged through these proclamations, part of these states, and then became part of B states. All these states became part of B states. Jammu Kashmir Mullahs were not. It was the only state excluded from Part B states.
But equally, the proclamation which Yuvraj executed, which you find at page 379,
Yes.
which we have seen earlier,
Yeah.
says that the entire relationship between Jammu and Kashmir and the Union of India will now be governed by the Constitution of India.
Correct.
And all previous understandings
Are gone.
are all superseded.
Absolutely. And see what the language is. The Constitution of India shortly to be adopted shall be insofar as it applicable to the state of Jammu and Kashmir, govern the constitutional relationship. So you go back to that. That is 1 and 370 only, Malak. Nothing more than that. I just wanted to show your lordships, Malak, because your lordships put me this question. I think it was a very significant Malak's query. And they all followed a uniform pattern of integration, other than Jammu Kashmir. And Malak, the white paper also says that the integration of states did not follow a uniform pattern in all cases. You will find that, Malak, at page PDF 46.
Because you have to deal with them differently. All the
Naturally.
I have understood that argument. Today the issue is not this. Today the issue is whether 370 was really a temporary thing and whether in terms of 370 it could have.
I'm giving the historical background to show the difference and why he did not merge, because in the meantime many things had happened, including the matter going to the UN. This all happened prior to this, Malak. Therefore, the question of merger didn't arise. That's the point, Malak.
That has all been argued in your opening arguments.
No, I'm only giving the background to 370, Malak. I'm not arguing it. My lord put it to me. I'm just giving the background, nothing more. I'm not arguing. I've argued 370, Malak. I'm not arguing, Malak.
Historical background also you are given in your opening argument.
No, not the merger, because my lord put me the merger agreements. There's a difference between merger agreements in all other states at that time, that is the 552 states, and except for Jammu and Kashmir. That's all, brother. And they have argued merger. I did not argue. Anyway, be that as it may, Malaj. Malaj, if just one other thing, Malaj. Since we are at this, Malaj, your lordships put to me yesterday, and then I'll come back to Malaj, the 355. Your lordships put to me that, look, there is a silence here in the Constitution. Malaj, I just want to answer that. And I'll Malaj, read what I have to say on this, Malaj, so that it's on the record. My first statement is integration was completed when the Constituent Assembly of Jammu and Kashmir completed its task and the Constitution of Jammu and Kashmir was adopted on 26th of January 1957. The governing structure comprising the Constitution of India and the Constitution of Jammu Kashmir complement each other, and through the bridge of Article 370. The scheme operated without conflict for 70 years. This very scheme. There was never a conflict. 2, through this complementary structure, the vast majority of provisions of the Constitution of India are applicable to Jammu and Kashmir in one way or the other. This was the integration meant. Nothing further needs to be integrated. Indian constitutionalism is not bound by a single scheme of legislative relations or any homogeneous understanding of the concept of integration. 3. Article 370, sub-article 3 is not silent. What is my answer to that? It is not silent as to the consequences reflecting the relationship between Jammu and Kashmir and India after the Constitution of Jammu and Kashmir was framed and the Constituent Assembly completed its constitutional task. This is further buttressed by the fact that in 1954, by CO 48, a proviso was added to 368(2). That can't mean that the 370 was silent on the consequences. If it was silent, 368(2) proviso would never have been added. Ensure that Article 370 could not be amended even through the exercise of constituent power, and that by virtue of CO 48, the boundaries of the state of Jammu Kashmir could also not be altered as long as 370 was in place. The Article 368 does not apply to 370 is clear from the fact that 370 starts with a non-obstante clause. So it was not silent as to the consequences. Next, there were no silences left to fill except the silence of the people of Jammu and Kashmir, who were never consulted and taken into confidence when issuing CO 272 and 273. That's the only silence that prevailed. Bilateralism is at the heart of the mechanism provided by Article 370, in terms of which laws applicable in the Union of India through the Constitution of India as applicable to Jammu and Kashmir are to be applied. It is this bilateral process which allows for a process of integration that is constitutionally envisaged in Article 370 of the Constitution, and any adjustment of the relations between Jammu and Kashmir and the Union must follow this bilateral process. And last of all, even with respect to 368 of the Constitution, the process of exercise of constituent power resulting in amendment of the Constitution is also given effect through a bilateral process. Bilateralism is at the heart of the said process because you have to consult at least get agreements of at least half the members of the states. That too is a bilateral process. Nothing can happen outside there can't be a unilateral act of an executive, not even parliament. Consider this, Malas, what we're talking about, a unilateral act of the president acting on the aid and advice of Council of Ministers, not parliament. So, Malas, with respect, I say there is no silence. So that was, Malas, just our submission, Malas, on that issue. And then kindly have a look quickly at the Constitution of India for a minute, Malas. Kindly, Malas, just look at this. Yes. Now, if you see, Malas, I'm not going to read the language. Just want to ask your lordships to notice three things. One, there are entire Article 370 has 2 colons. The rest are all semicolons. And the 2 columns reside where, Malas? They reside in D. There's a colon after D. And there is a colon after 3. 370 sub-article 3.
Colon after D.
D, Malas 37 1D. And colon after 370 sub-article 3. So you cannot exercise that power independent because it's integrated. The process is integrated, and it's only a process that we are talking about. We're not talking about powers here. 370 is only a process of integration. And Miller's Constitution Bench and Manohar mentions that. And we are dealing with the process adopted by the government of India consistent with this process of integration. We're not talking about anything else, Millers. There is no unilateral notification issued by the government of India, by the President on the aid and advice of the Council of Ministers that's before you. There is no unilateral declaration. And I'll assume for a moment, Millers, there is a silence. How will your lordships, Millers, integrate that silence into 272 and 273? Because 272 and 273 deals with 370 sub-article 3 as it stands. You will still have to say whether 273, 272, 273 is consistent with the unilateral notification to be issued by the president, which is not there and which is not before you. It's not possible to match the two. It's not possible for you to state constitutionally, Malaj, that 370 notification or under sub-article 3 will justify the action taken, which is 272 and 273, which has nothing to do with the notification. If you uphold 272 and 273, you will have to uphold it on its own terms, not on terms other than 270 sub-article 3 and the proviso, because that's what they have adopted. Even if you were to accept that argument, it's not possible for your lordships, with the greatest respect to Malaj, uphold the action under 272 and 273. And so I was, Malaj, that's one thing I was saying. Now kindly see, Malaj, please kindly see. And kindly see the absurdity of this. The absurdity is that when it comes to 371, B1 and 2, you have to consult, or you have to, the state has to concur. If it comes to 370, 1B, again you have to consult and or concur. When it comes to 373, you can abrogate without consultation, without concurrence. How can that interpretation ever be accepted by a constitutional court? Means that you don't need consultation, you don't need concurrence. You can unilaterally do it. For everything else, you'll need that. That's a constitutional absurdity. For individual articles, you have to concur, but for the whole abrogation, you don't have to concur. Even for a law, you have to concur, Malaj. This is, I with the greatest respect, Malaj, at least take the text and the context, Malaj, not a pretext. Now, Malaj, I just want one other thing. If you look at Article 371, notwithstanding anything in the Constitution, starts with it. Your Article 371A, notwithstanding anything in the Constitution. And then 371A sub-article 2, notwithstanding anything in the Constitution. Then, Malaj, special provision with respect to State of Assam, notwithstanding anything in the Constitution. 371C, notwithstanding anything in the Constitution. None, the 368 will not apply to any provision of the Constitution in this chapter. Is that not against basic structure? If the argument is, at least I didn't argue the basic structure, but otherwise, that's also against basic structure. Why don't you set aside the entire chapter? Every provision other than one, which relates to Andhra Pradesh, starts with notwithstanding anything in the Constitution. Could be, it could be. Now, as far as Jammu and Kashmir was concerned, they had an added protection, the proviso, to 368. That constitutionally means that the complete merger that we are talking about, dehors the proviso, could never be done. There could be an argument as far as other articles are concerned. You may still apply, you use 368. You may argue that. To what extent it will be upheld or not is a separate issue, because in some of these articles, even treaties cannot be changed. Some of these articles have treaties, Malaj, between the government of India, which was entered into in the past, cannot be changed. So whether 368 will apply or not, we are not into this. I'm just getting you the scheme, Malaj. So, Malaj, I'm done with this. Now, Malaj, I come back to my try and finish as quickly as possible, because a lot of eminent counsel are waiting for me to finish, which I wouldn't wish to do, Malaj. I want to Now, Malad, just one other thing before I move on. Show me the, no. Give me the, looks at my note, Malad. Your Lordships don't mind, which is now rejoinder. Yes.
What page, Mr. Chairman?
Malad, that is rejoinder. I don't know.
What page of the rejoinder? Rejoinder that we have.
Page, I'm just giving your Lordships. Page, Malad, kindly come to 23. Where is that interpretation? I'm sorry, Gopala Swami. Sorry, Malad, 17. I'm sorry, I apologize.
Page 17.
16. Starts at 16, but at 1:7.
Yes.
Now, Malad, your Lordships will see the centrality of this, that he is part of the drafting committee. He is, Malad, piloting the bill. My Lords, has it, Justice Vivekanand?
Yes.
Now, just see, Malad.
This we have already.
No, just one last sentence, Malad, of this. But before he issues any order of that kind, that is under 373, the recommendation of the Constituent Assembly will be a condition precedent. That explains the whole of the article.
That's been the.
No, that's the understanding throughout, Malad, till 5th of August. And our interpretation is consistent with it, and their action is consistent with it, which we are now challenging. So that was one. Then, Malad, now I come back to that argument, Malad, that I made yesterday. That once the dissolution took place, 356 could not have been imposed as a matter of law.
That point to make.
And if 356 couldn't have been imposed, all that happened by virtue of the power under 356 is all illegal and void. Because the structure of the Jammu and Kashmir Constitution is entirely different. My Lord knows that any act of dissolution has to be done on the aid and advice of Council of Ministers. That applies not just to Jammu and Kashmir, but to the rest of India. No dissolution of an assembly can take place without the aid and advice of the Council of Ministers. Therefore, Malad, constitutionally, the dissolution on the 1st of November was void. And you can't interpret the act of the governor and the powers of the governor and the responsibility of the governor different from other states in India. That as far as governor of Jammu and Kashmir, he can do it, but the rest of the India, governor cannot do it because the provision is the same. So if that action is bad, 272 has to go. 273 has to go. And even if you assume that action is good, you can't exercise this power under 356. So 272, 273 will still have to go. Because the power is only the power to make law. You are the delegate of Parliament, of the legislature. You can only make law. You can't change Article 3. And whereas my learned friend, the learned Solicitor General, cited several instances of 356 where Article 3 is suspended, but not with reference to the change of Article 3. That's the usual procedure that was followed. But not to change Article, to amend Article 3. That is never the power given. And that is apparent in 357 subclause 2, Malad. Kindly see 357 now. It's in my note itself, Malad. I'll just give your Lordships the page. Page 25, PDF 25. Yes. Kindly see. Para 60, Malad. My lord has, all my lords have 357 sub-article 2.
Yeah.
Majestic Gawai has it, Mullah. This is 25. PDF 25, 357-2. 357-2. Any law, Mullah, as applicable to Jammu and Kashmir. That's very important. Any law, I'm sorry, Justice Khanna. Any law made in exercise of power of the legislature of the state by parliament or the president or other authority referred to in subclause A of clause 1, which parliament or the president or such other authority would not, but for the issue of proclamation under 356 have been competent to make, shall, to the extent of the incompetency, cease to have effect on the expiration of 1 year after the proclamation has ceased to operate. So how could 272 be issued? Any law made has to expire after 1 year under the Constitution of Jammu and Kashmir. One of the distinguished counsel on the other side didn't read this part. He read Mullah 357-2, which is different, which is the Constitution of India. Any law made in exercise of power of the legislature of the state by parliament or the president or other authority referred to in subclause A of clause 1, which parliament or president or such other authority would not, but for the issue of a proclamation under 356 have been competent to make, shall after the proclamation has ceased to operate, continue in force until altered or repealed or amended by a competent legislature. So how do you, Mullahs, amend Article 3 of the Constitution and justify it? Either under 356 or under 357, because the legislature has the power to set it, to make law. How do you then do it? And that also temporary emergency laws, remedial laws. It was original 350s.
Just read the last portion once again.
Yes.
One, it says law made. Is it talking about legislation made, legislation in form of laws or enactment
Yes, yeah.
made? And read the last part.
Last part, which shall so cease
Yes.
to have effect as are sooner.
To have effect on expiration of period after the proclamation has ceased to operate,
That's correct.
except as respect to things done or omitted to be done before expiration of the said period.
Yes.
This part will have to be explained. Unless the provisions which are so ceased to effect are sooner repealed or reenacted with or without modification by act of appropriate legislature.
That's correct. So, Mullahs, how can that appropriate legislature, when it comes into being, ever do this?
Just two things, Mr.
Yeah.
Sibal. One, is it dealing with laws made and not with the effect of, will it apply also to Article 370? Or for that matter,
Once there is,
Article
once 356 is there, it will apply.
just, we are not, it's a matter of interpretation.
Yeah.
It's not a matter of taking sides.
I agree, Mullah. I'm not taking sides. I'm only taking my side, Mullah.
You are doing that.
Yes, that I'm entitled to take, hopefully, Mullah.
One, it says law made. Will it also apply to the power exercised by the legislature in terms of the Constitution? One aspect. The second is, to the extent of incompetency,
Correct,
cease to have effect on expiration of period of 1 year
correct,
after the proclamation ceased to
right,
operate, except as respects of thing done or omitted to have been done before expiration of that period.
correct.
So what it also protects is whatever has been done or omitted to be done before expiration of that period
Correct.
will be protected.
Correct, absolutely.
Will this not get covered in that part?
It won't, because this is an amendment of the Constitution. It's not a law.
Then you aren't contradicting yourself.
I'm not. It's not a law. This is not a law, Mullah. This is an amendment to the Constitution.
So what it talks about is laws, not
No, because you're a delegate of Parliament, of the legislature. In other words, whatever power the legislature has to make laws, you can make laws. Malas 356 is not an omnibus position to Malas take over the legislature and do what you like.
Mr. Sibal, when we interpret, we have to interpret the section without taking, you may say in the contextual interpretation, we have to take the whole background.
I'm sorry to say that's covered by Boma Malas. That's not covered. That's not. There's no cavil to it. That's covered by Boma. And I've cited all those passages of Boma to your lordships already.
Yes, ma'am.
Let's not find any other power. That's non-existent. The temporary provision.
Second part.
But Mumbai 153 4C.
Says, when we interpret, especially because your lordships interprets the constitution, we only make arguments. It's for posterity. It's not for this case or that
Yeah,
case.
you don't have to remind us.
Your lordship knows that. If you give such a
No, I
power
think-
to Parliament under 356, your lordships, anything can happen. Anything can happen. And as I said that the other day, and I'm digressing a bit, with respect to Maharashtra, I said, if Maharashtra is upheld, it will happen again. And it happened in Maharashtra itself. Because we have to protect the Constitution. We don't have to do anything more than that. Our at both sides, mothers, endeavors to protect the Constitution. And your lordship upholds it. That's our task. And upholds it for posterity, not for a particular case.
357(2) of the Constitution of India.
Yes, I will. Which was, I'm sorry, PDF. I got it, yes. Yes, I will. Has ceased to operate, continue in force until altered or repealed or amended by the competent legislature or other authority. That's right.
What's the difference between the two?
Difference is that is 1 year.
1 year.
Yeah, that's only, that's.
And protection, whatever is.
Yes, in other words, the
and
legislature can
permitted to be
undo
done.
it. The legislature, because it's been a delegate, before Parliament is a delegate.
But in both the cases, it's law made and exercise the power of legislature.
Yes, absolutely. That if this is a law made, if your lordships believes it's a law made, then within 356, because 356 is to restore democracy, and it's only a temporary measure. Right? And Malat, not only that, you cannot take irreversible action. That also is decided by this court. That during this time, Malat, your lordship knows the difference between state of Rajasthan and Bomai. In state of Rajasthan, they said, in Bomai, they said, you must dissolve after the proclamation has been accepted by both houses of Parliament. You can't do it before. Until then, suspension, which is what I was saying yesterday to your lordships. Now, that's irreversible. Therefore, Bomai said you can't do it. Rajasthan said it's possible before approval. Bomai disagreed. That can only happen after approval. But here what happened? It happened before. And it happened without aid and advice. That's even worse. I could have understood if the governor has sent a report way back on 20th of June. I could have understood then, but not in this fashion. Therefore, the whole motive was political, and I've been saying that from day one. The motive was political, the process was political, but the end result was unconstitutional. And I've already pointed that out. Let's not take more time with the court. What did Ambedkar ji say? He said, I cannot altogether deny that there's a possibility of these articles being employed for political purposes. So what I've said before your lordships is no different from what Ambedkar ji said. His fears have turned out to be right. So, therefore, now let's kindly come to come to the argument. I've done with the dissolution part. I've done with 356. Your lordships have read all the judgments, I'm not going to repeat anything. Now I come to the argument of impossibility. An argument not raised, not part of the counter affidavit, not part of any pleadings, not part of any proclamation, not part of arguments the last time also, not part of the first set of written submissions, and yet we have to deal with it. Now, let me tell you, lordships, the principle of impossibility, constitutional principle of, I'll just enunciate it. If there is a constitutional obligation to be performed, and it has to be performed, then in furtherance of that constitutional obligation, the principle of impossibility of performing another obligation comes in. Give your lordships an example. The term of the assembly is 5 years. Assembly is dissolved in 4.5 years. There is no assembly. And the judgment my learned friend cited, there is a presidential election or election of the vice president, and members of assembly have to vote. But the term of the assembly expires in 5 years' time. The Constitution says you have to perform that obligation. So if the assembly is in dissolution, it's impossible for them to vote. That's the constitutional principle. Where is the obligation under 370? It has to be stated in the Constitution. You can't silently invoke it. And 376 probably free bill may, not shall. There is no obligation. That's the principle of impossibility, which has absolutely no application. How is it impossible, Malat? Why is it impossible? No, you've made it possible by acting the way you've done. That's the way to do it, Malat. Now, whether that's constitutional or not is a different issue. But it's certainly not impossible. If you uphold it, it's not impossible. If you don't uphold it, it's only unconstitutional. Beyond that, your lordships are not asked to decide. So where is the question of impossibility? That's my answer, Malat. And the judgment that my learned friend cited, Malat, what's that judgment? In a presidential election is exactly that. Namely, The election had to take place, voting had to be done, the assembly was dissolved. So how could they have voted? The proclamation was there. So that's the constitutional principle. That's it. Anything else? No. They have already. Very quickly, I'll take about 10 more minutes and I'm done. Numbers. Kindly come to 272. Where is it? Page 27, PDF, page 27. Volume? Yes, my rejoinder, PDF 27. I mean, it's just, I've already argued it, Malad, that this is all beyond Malad, the powers of the president. And in any case, he has to act on the aid and advice of the Council of Ministers. So Parliament also has nothing to do with it. And Malad, it doesn't need concurrence, doesn't need consultation. That argument I've already made. And if that can't be done, Malad, then we're left with nothing. Then 273. Huh? No. Let's 273 now. But let's also kindly note. Nothing else. Oh, one second. 36. Well, let's kindly come to my the 367 argument that was made. The interpretation part. And then they relied upon Damnu Malad. That argument has already been made. I'll not repeat it, Malad. Damnu itself says that this particular change at that point in time was not a change in the substance of 370. In the Jammu Kashmir Constitution is applicable, the word governor was already there. And therefore, you couldn't have interpreted it in any other way. So that's all, Malad. It's already been argued. Now come to Malad to Article 3. PDF 33.
Yes.
So, Malad, as far as Article 3 is concerned, Malad, let's assume I've made my arguments on the proviso already, Malad, that under 356 it can't be done. But now let's assume the proviso is not there. Let's assume that, Malad, all this is valid. Let's assume. Malad, how can they make the union, a state into a union territory? Under what provision of law? Okay, under which, what power? Then my Lord put to them that there may be a situation of a national security situation. So therefore, temporarily, you may need to do that. But the national security situation is dealt with by Article 352 of the Constitution. 352 to 359 deals with all this. So how can you use Article 3 to do that? You can't use a power in 3, and of course that's not their case also. It's nobody's case that this was being done because of national security. Pulwama happened, Malad, in February 2019 during President's rule. And then they had elections in May 2019. And what is the justification of keeping, not constituting the state, Mullah, for 4.5 years? Under what constitutional basis can you say that I will keep a particular state as union territory for 4.5 years? You say you are going to have municipal elections. You're going to have local government elections. There are a number of, the tourism has increased. So what's the impediment then? What's the constitutional logic, Mullahs, or basis on the basis of which you can deny the people of Kashmir a statehood, and Mullahs, India is a union of states. As your Lordship rightly said, my Lord the Chief Justice, that a union territory can get the status of a state, but not the other way around. It's never happened in the history of this country. Actually, 272, 273, all this has never happened in the history of this country. Not even during emergency. So, Mullahs, just one last thing, and then I'm done. I want to show you the annexures in this, Mullahs. This is my argument in 3, Mullahs. Others will deal with it in some form. I want to show just one. Yes, kindly see PDF 42. Now, this is dated 17th May 1949. But as your Lordship will notice here, and this is all documents are provided in the annexures, that at this point in time, Iyengar, Sheikh Abdullah, and Vallabhbhai Patel and Nehru were all getting together to draft 370. And on 17th May 1949 is a letter written by Gopalaswamy Iyengar, and he tells Vallabhbhaiji, here's the draft. Jawaharlalji has seen and approved of it. Will you kindly let Jawaharlalji know, direct as to your approval of it? No, directly tell him as to your approval of it. He will issue the letter to Sheikh Abdullah only after receiving your approval. Vallabhbhai Patel was the architect of 370. Nothing was done without his approval. In fact, he went to Parliament. Kindly see, there's another letter, another document here. 3rd November? Yes. It's very interesting with us. 3rd November. No, not 3rd November. No, yes, 3rd. Yes, where is it? Yes.
But look at Sardar Patel's letter at page 46.
46, yes. Correct. That's the draft, Mullahs, of 306A. Kindly come to 244, Mullahs.
Right, that's that letter.
Thank you for your letter of 15th, which I have received only this afternoon on my return from the Constitution. 1 second. I find there are some substantial changes over the original draft, particularly in regard to the applicability of fundamental rights and directive principles. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. I do not at all like any change after our party has approved of the whole arrangement in the presence of Sheikh Saab himself. Whenever the Sheikh Saab wishes to back out, he always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government or even on his personal basis to you and the Prime Minister, who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is the right thing to do, you can go ahead and do it. Now, see the next document, 3rd November. There was some, again, this is by Vallabhbhai Patel. There was some difficulty about the provision relating to Kashmir. Sheikh Saab went back on the agreement which he had reached with you in regard to the provision relating to Kashmir. He insisted on certain changes of a fundamental character, which would exclude in their application to Kashmir the provisions relating to citizenship and fundamental rights and make it necessary in all these matters as well as others not covered by the accession to 3 subject to seek the concurrence of the state government, which is sought to define as the Maharaja acting on the aid and advice of Council of Ministers appointed under the proclamation on 8 March 1948. After a great deal of discussion, I could persuade the party to accept all the changes except the last one. He was the one who was interacting with the party. And he was the one who finally, Mullahs, persuaded the party to accept all the changes except one. And of course, Sheikh
This
Abdullah
will
thereafter.
only show there was a political compromise to ensure
That's all
enough
right.
flexibility at later point of
Absolutely.
time.
All I'm saying is
But
that everybody
there's
was
another
part of
part,
that process.
You are accepting the second part also, that there was flexibility to ensure that in future it works itself out.
That's correct. Well, all that I'm saying is, Marat, they were all collaborating. The key players were collaborating in drafting 370, and this is how they understood 370.
That argument you have already
Yeah, I've
made.
already made. I'm not repeating it, Marat. I just wanted to read these letters. So, Marat, and then I've got this table, Marat, of Jammu Kashmir, Marat, where Jammu Kashmir is ahead of most of the states in India in every parameter. But we are not concerned with that, Marat. I just put it. So that's all I have to say, Marat. I just want to say at the end that, Marat, as I said, Marat, your lordships, Marat, ultimately is the arbiter of what this constitution should look like and how it's to be interpreted. But I only want to request your lordships to think of one thing, that as I walk out in silence of this court, let the court speak on behalf of the people of India. Because this court, this government, or any government, any administration acts for the people of India. And it should not be that acts are done when a part of the people of India are silent, who have never been consulted, and whose fate will be decided by the cabinet sitting here without reference to parliament, without reference to legislature, without reference to the people. Those people are central to the Constitution of India. We should not forget that. Thank you very much for giving me this time. Excuse me for a while, but let's feel that.
Mr. Subramaniam, you'd be arguing.
Yes, my lord. My lord, am I audible? Am I visible?
Both, Mr. Subramaniam.
Yes.
Thank you, my lord. My lord, I just want to make a few brief submissions on Article 370 in the light of your lordship's questions and observations. My lord, it might have begun as a temporal provision initially. I don't think anybody can dispute that people envisaged it as of temporality. But, my lord, the provision had adequate evidence, intrinsic evidence in its words to suggest that it could be there to stay. And that is what has happened. And my lord, this is the crux of the matter. Has it happened in a manner known to Article 370? My answer, my lord, is yes. In a manner known to Article 370, Article 370 stays. Now, my lord, how has this been achieved? As your lordships would notice, that it was a Constituent Assembly of India which gave the people of Jammu and Kashmir the ability to determine their political future through a constitution. The instrument of accession, my lord, did not completely transfer sovereignty, as held by Justice Gajendra Gatkar in Pramnath Kaul's case. The instrument of accession itself had reservations that it was intended to abide by a future constitution of future determination by the people of India, which is why Justice Gajendra Gadkar said that until the 1939 Constitution was there, the Maharaja was still enjoying a certain kind of sovereignty to make laws, and therefore, my lord, upheld the law in question. Now, my lord, when does integration become complete is the question. And, my lord, in this case, unlike the cases of privy purses, unlike any other case, the sovereignty actually transfers from the king, from the monarch, to the people. And this transition from the monarch to the people is the common framework of both the Constituent Assembly of India and a Constituent Assembly to be formed. The notification of 25th November 1949, my lord, expressly uses the words Constitution as applicable, or insofar as is applicable, because that is how Article 306A of the draft Constitution presaged it. Well, on Article 306A is the only article which refers to the instrument of accession and refers to the matters contained in the instrument of accession as limiting the power of Parliament to make laws. Therefore, my lord, the instrument of accession expressly finds a place in Article 371 of the Constitution. The expression Constituent Assembly also finds a place in Article 370 of the Constitution. But there was a very important question which the Chief Justice has voiced on a few occasions. What is there to show that the Indian Constitution recognized a Jammu and Kashmir Constitution? I thought it was a very critical question, and I have, my lord, two answers. The Constitution does recognize the Jammu and Kashmir Constitution. May I invite your lordship's attention to the text of Article 370 itself that recognizes, my lord, that Constitution. Please, my lord, look at Article 370 with me for a moment. In Article 370, after subarticle 1, 2, and if your lordship sees 2, if the concurrence of the government of the state referred to in para 2 of subclause B of clause 1, or in the second proviso to subclause D of that clause, be given before the Constituent Assembly, and may I request, my lord, your lordships to look at the next few words. For the purpose of framing the Constitution of the state is convened. Constitution of the state, my lord, is no other constitution except the Jammu and Kashmir Constitution. And, my lord, there is a second piece of evidence in the Constitution which has not yet been brought to your lordship's attention. There was, my lord, the state reorganization in 1956. The concept of Part B, Part C, all of them disappeared, if your lordships recollect. The Constitution's 7th Amendment Act, my lord, in Article 152, inserted the words excluding the state of Jammu and Kashmir. In Article 152. This is, my lord, 7th Amendment. And, my lord, the dates are slightly significant. Very important, my lord, is the date. The Seventh Amendment was assented, my lord, on the 19th of October 1956. And, my lord, by this time, the draft constitution of Jammu and Kashmir was introduced on 10/10/1956. And the draft constitution of Jammu and Kashmir established the High Courts of Record and established the legislature under its constitution.
What happened on 10/10/56, Mr.
In 1056, my lord, the draft constitution of Jammu and Kashmir was introduced for adoption. And that constitution, my lord, clearly had provisions for executive, the legislature, and the judiciary to be established in terms of that constitution. So institutions, my lord, were established under that constitution. And therefore, Part 6 was rendered inapplicable by the insertion of the words in the Constitution's 7th Amendment Act, excluding the state of Jammu and Kashmir. So, my lords, it was a very valid question that your lordships put to us. Is there any evidence, apart from conduct, which I'll deal with separately, in terms of constitutional conduct, that the Constitution of Jammu and Kashmir is alluded or is cognitively taken note of? It is alluded in the words in my submission in sub-article 2. It is cognitively taken note of because that chapter relating to Part 6 was rendered inapplicable under Article 152, which is why your lordships notice now the CO 273, it seeks to exclude that exclusion. It refers to 152, it says, notwithstanding anything in this constitution. So, my lord, I submit that the Jammu and Kashmir constitution does find a place. But let's come to a more critical point about the word recommendation in sub-article 3 and whether sub-article 3 was in fact employed. It's a very critical question your lordships asked. The word recommendation, my lord, was chosen consciously because the Constituent Assembly of Jammu and Kashmir, my lord, was not constituted by the Government of India or any initiative of the Government of India. It was under a proclamation of the Maharaja under the Jammu and Kashmir Constitution. That Constituent Assembly, my lord, was not an emanation of the Government of India's Act. Second, my lord, an order which had to be issued under Article 371 necessarily had to be an order in the name of the President. And that's, my lord, because all executive power vests in the President. The argument of President being answerable to Parliament, I'm sorry, my lord, with respect, is completely contrary to the decisions of this court with reference to the Westminster style of government which we have adopted, which Dr. Ambedkar on the 4th of November, when he introduced the Constitution, he spoke about the role of the President. And, my lord, I submit, under Article 81, the President, my lord, is a part of Parliament. I was a little surprised, my lord, to say the President is answerable. My lord, he is a part of the Parliament. Parliament, by very definition, includes the President and two houses, my lord. And under our Constitution, my lord, the President can never act without the aid and advice of the Council of Ministers. The governors could, under Shamsher Singh, but not the President. So, my lord, a claim of untrammeled discretion and power in the President under Article 371 itself, my lord, is flawed. But now, my lord, let's see how events have played out. Your lordships wanted to know, was sub-Article 3 employed? Was there anything to show that it was effectuated? And I say, my lord, it was effectuated in 4 different ways. The summum bonum of all the 4 steps is it was effectuated. And, my lord, the decision to abrogate Article 370 cannot be taken ad nauseam. It was meant to be taken once. It had to be taken by the Constituent Assembly. Now, my lord, let us look for evidence of it. The first is, please look at, my lord, CO. If your lordships will look at CO 42. Would your lordships kindly go to the documents volume for a moment? Please go to, my lord, document volume 3. And would your lordships kindly come at page 12 of the PDF. CO 44, I'm sorry, CO 44. Please see, my lord, this. My lord, this is on the recommendation of the Constituent Assembly. PDF 12, my lord. And if your lordship says this is a declaration under Article 373 of the Constitution. And if your lordship now sees the declaration, in exercise of the powers conferred by Clause 3 of Article 370 of the Constitution of India, the President, on the recommendation of the Constituent Assembly of the State of Jammu and Kashmir, is pleased to declare that as from the 17th day of November 1952, the said article shall be operative, with the modification that for the explanation in Clause 1 thereof, the following explanation is substituted, which, my lord, is about the Sadr-e Riyasat. But, my lord, this is a decision under 373. What was the next decision? The next decision, my lord, was again a recommendation of the Constituent Assembly, namely an invitation, my lord, to apply the provisions of the Constitution of India subject to certain modifications. That was a decision, my lord, again of the Constituent Assembly. It was a resolution of the Constituent Assembly. And that, my lord, is significant because that resolution was on the 15th of February 1954. Your Lordships will find that in volume D7 at page 978, and it was adopted in, my lord, D7, page 979. That annexure, my lord, which was the annexure attached to the report of the drafting committee, was tabled in the Constituent Assembly.
Where do we get it? At page 2,
My lord, volume D7. Has your lordship a volume D7?
PDF?
Yes. My lord,
979.
could your lordships first see volume D7 at page 937? Let me show that first.
937.
Yes, first 937, and then I'll show you, my lord, the resolution.
That's the report of the drafting committee?
Yes, this, my lord, was tabled before the Constituent Assembly. And in this report of the drafting committee, your lordships will notice at 938, PDF 938, would your lordships look at the first sentence? The provisions of the Constitution of India, which in addition to Article 1 and Article 370 should apply in relation to the state of Jammu and Kashmir and the exceptions and modifications subject to which they should so apply will be as follows. And then, my lord, all these are extracted. But what's important, my lord, is Article 1 and Article 370 in addition. This, my lord, is introduced on the 11th of February 1954. And on 15th of February 1954, if your lordships go to page 978, my lords, of the same volume, this was adopted. So, my lord, the first body which looked at the matter was the Constituent Assembly. They invited the application of the provisions of the Indian Constitution. And at 978, your lordships will see at the bottom of the page. Please look at the bottom, my lord. Resolution that having adopted the report of the drafting committee this day, the 15th of February 54, and having thus given its concurrence to the application of the provisions of the Constitution of India in the annexure to the aforesaid report, this Assembly authorizes that government of the state to forward a copy of the said annexure to the government of India for appropriate action. And that is how, my lord, on the 14th of May 1954, the 1954 order was passed. And your lordships will notice the words of that order. It's in volume D3, my lord, at page 13. Your lordships will notice
Volume 3,
that
page number, volume 3.
yes, volume D3, page 13, my lord.
Okay.
Your lordships will find an express continuance of Article 370. Please see page 13. This is the 54 order.
Yes.
And please come to 2. The provisions of the Constitution, which in addition to Article 1 and Article 370 shall apply in relation to the state of Jammu and Kashmir and the exceptions and modifications subject to which they shall so apply shall be as follows. And, my lord, this order of 1954 was again tabled before the Constituent Assembly. If your lordships go to volume D7 at page 990.
Circle 371, not 373. No.
And at page 990, my lord, your lordships will notice that in the Constituent Assembly, the 1954 order is laid on the floor of the House. Please see 990, Mr. Dogra. The recommendations of the House in this behalf had been sent to the President of India, who in exercise of the powers conferred under Clause 1 of Article 370 was pleased to issue Constitution Order 1954. I lay the copy of this order on the table of the House. As I told your lordships a little while earlier, the draft constitution, my lord, of Jammu and Kashmir was introduced by Mr. Dogra on 10/10/1956. Your lordships will find in the same volume at page 1058. In that same volume. Your lordships will see 1058 PDF.
Page number, please repeat.
Page number 1058 PDF, my lord, in volume D7. Otherwise, it has a red lettered page of 2417.
That's it.
And your lordships will notice, Mr. Dogra, sir, I beg to present the report of the drafting committee and introduce the draft constitution as settled by the committee. And your lordships may just see 4 lines later. The fundamental principle on which the draft is based are parliamentary democracy, responsibility of the executive to the legislature, joint responsibility of the cabinet, separation of the various powers of the state, executive, legislative, and judicial, and finally, the rule of law. One basic feature of the Constitution is that we have once again affirmed that the state is an integral and inalienable part of India and will ever remain so. There was a very thoughtful observation from my Lord Justice Gavai on Dr. Ambedkar's contrast of different models of federalism. But Dr. Ambedkar does say even the Indian Constitution shares sovereignty between the center and the states. However, it does not have the same nature of the American Constitution. It comes to an end there because they have separate constitutions for each state and they have citizenship for each state. But, my lord, here, the word which is used is only permanent resident, not citizen, my lord. All Jammu and Kashmir residents governed by that constitution claimed and asserted that they are Indian citizens. I'm going to show that, my lord, in a moment. Now, this, my lord, is the draft constitution. Now, would your lordships kindly come to 1910-56? You just have to look at Article 152 in your, my lord, in the Constitution. Please have a look at Article 152.
What was the date, Mr. Subramaniam?
That, my lord, came on 19th October 1956. Your lordships will find that at page 101 of the Constitution, PDF.
That is the 7th Amendment.
That is the 7th Amendment, my lord.
And it came into force on 1st of November 1956.
Absolutely, my lord. And your lordships will notice the parentheses. This recognizes the J&K Constitution because the establishment of the Raj Pramukh or the governor or the institutions of the legislature executive and the judiciary were undertaken under that constitution. So your lordships notice in the definition article 152, in this part, unless the context otherwise requires, the expression state and then does not include the state of Jammu and Kashmir. Now, my lord, the constitution of J&K was adopted after this. This is 1/11/56. The date of adoption of the Jammu and Kashmir constitution was, my lord, actually 17th of November 1956. And, my lord, in line with the date of coming into force of the Indian constitution, they made the effective date as 26th of January 1957. And the J&K Constitution, your lordships will find, is in volume D2. And it is at page 17.
Volume D2.
Page 17, my lord.
Mr. Subramaniam, what seems to have happened was this. During the period when, after our constitution came into force on 26th of January 1950, Jammu and Kashmir was a Part B state. Now, in relation to the Part B states, Article 238 of the Constitution made provisions for modification of Part 6 of the Constitution.
Right, my lord.
Therefore, to the Part B states, Part 6 would apply with the modifications which were spelled out in Article 238. Article 371A, however, stipulated that
238 will not apply.
will not apply to the state of Jammu and Kashmir. Right? Now, that was that period when the Constitution was yet to be drafted. After, with the 7th Amendment, Jammu and Kashmir ceases to be a Part B state. It becomes a state within the meaning of Article 13A of the Constitution.
Right,
The distinction between Part A, B, C, and the Part D territories vanishes after the 7th Amendment. So when Jammu and Kashmir ceases to be a Part B state, automatically some provision had to be made. It was not governed by Article 238. So other Part B states, which ceased to be Part B states, were governed then by Part 6. Jammu and Kashmir was not within the fold of Part 6 for the reason that so long as the Jammu and Kashmir Constitution continued to hold the field, that Constitution made provision for the executive,
Yes.
the legislature, the judiciary, so on and so forth. So this provision in Article 152 was in continuum.
Exactly.
Because from the inception, Article 238 had no application. And
Right.
once it came within the fold of not a Part B state, you have to make some provision. Now, that provision, according to you, was made in the Constitution of Jammu and Kashmir.
My lord, absolutely. This is the point I'm making.
Right, but that doesn't tell us the basic question as to whether that was intended to be a permanent arrangement.
Yes. Now, my lord, for that purpose, if your lordships now take the Jammu and Kashmir Constitution, because, my lord, that's a little important. Your lordships are absolutely right. We have to look for evidence in the instruments themselves. Let's look at the Constitution of Jammu and Kashmir. Because the Jammu and Kashmir Constitution, my lord, actually not only makes integration absolutely beyond any pale of doubt. Unity and integrity with India is beyond a pale of doubt in that constitution. It, my lord, reserves provisions for the application of the Constitution of India in the state of Jammu and Kashmir. My lord, that's quite significant. If your lordship just takes that for a moment. Please look at, my lord, their preamble. Because, my lord, what we are concerned with in this case, we have used different expressions like consent of people. We have used the expression people. But, my lord, let us look at their preamble. This constitution was inspired, quite rightly, as my lord the Chief Justice said, by various constitutional provisions. And, my lord, it was many of the exceptions in the 1954 order were also inspired, my lord, I'm going to show to you shortly when we come to Parathe's case, by the American Constitution. But I'll show that in a moment. Please come to the preamble. We, the people of the state of Jammu and Kashmir, having solemnly resolved, in pursuance of the accession of the state to India, which took place on the 26th day of October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof, and to secure to ourselves justice, social, economic, and political. Well, this word, justice, political, will be of some significance in the light of Dr. Ambedkar's own exposition. This is, my lord, a resolve, and therefore they adopt this constitution. What is now, my lord, important is the Constitution of India, and which your lordships will notice is in 2(1)(a). At page 17. The first definition, my lord, is for the Constitution of India. Constitution of India means the Constitution of India as applicable in relation to this state. And then your lordships may kindly see 3, 4, and 5. Three is relationship of the state with the Union of India. The state of Jammu and Kashmir is and shall be an integral part of the Union of India. Well, Lord, this is a part of a constitution. What is the further integration we are talking about? It is an article of faith. It is a parchment of pride. For the people of Jammu and Kashmir, they have set this in the forefront in Article 3, which is called Section 3 by commentators. Then please see 4, the territory of the state shall comprise all the territories which on the 15th day of 1947 were under the sovereignty or suzerainty of the ruler of the state. And 5, my lord, please notice 5. The executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. But, my lord, under the provisions of the Constitution of India as applied under an order under 371. And, my lord, thereafter, your lordships will notice Section 6, sorry.
The domain of the Constitution of Jammu and Kashmir was that which was defined by the Constitution of India.
Yes. Now, my lord, I'm now saying Constitution of India here meant.
Therefore, this was
yes.
not that. This was not therefore a constitution which was at par or superior to the Constitution of India. It can't be superior to the Constitution.
No, it is not superior. It's not superior.
Nor was it at par with the Constitution of India, for the reason that, look at the two definitions, 2(1)(a).
Yes.
Constitution means the Constitution of India as applicable in relation to the state.
Yes, my
Now,
lord.
where would we find the nature of the application of the Constitution of India to the state of Jammu and Kashmir? Not in the Constitution of Jammu and Kashmir, but in the Constitution of India.
Agreed.
Right?
Agreed, my lord. That is why your lordships are right.
Right.
Under section 5,
Right, Section 5 also.
yes, under the provisions of the Constitution.
Legislative power of the state extends to all matters
Yes,
except those with respect to which Parliament has the power to make laws for the state under the provisions of the Constitution of India.
correct, my lord.
Therefore, the domain of Parliament to make laws for the state would be defined by the Constitution of India, not by this Constitution.
I'm grateful, my lord. Now I'm taking you a little closer to the point that if it meant under the Constitution of India, it also meant the order under 371. That's the point I'm making. And, my lord, that way, there is nothing, in this case, my lord, the two constitutions are, I'm not saying this is superior. Please don't get me ever wrong. But, my lord, I would not like to say easily that it is inferior because it has established courts of record and a legislature. It's a constitution, my lord. The Jammu and Kashmir High Court owes its existence to this constitution. The legislature of Jammu and Kashmir owes its existence to this constitution. They have been established, my lord. These are institutions of a permanent nature established under the constitution.
Who would
My lord,
appoint
there is no
judges to the
question
High
of
Court of Jammu and
superiority.
Kashmir? Who would appoint judges to the High Court of Jammu and Kashmir?
My lord, that also is provided. The Chief Justice is involved. The Chief Justice of India is referred to. This constitution, my lord,
President would
refers...
appoint judges to the High Court of Jammu and Kashmir.
Yes,
The President would transfer judges from the High Court of Jammu and Kashmir.
yes. But, my lord, I'm saying the establishment of the institutions or their genesis not to the Indian constitution per se, but to the J&K Constitution. My lord, I'm on the establishment of the institutions. Thereafter, they're administered naturally by the Chief Justice of India when appointments are made. But the important point, my lord, is that this constitution creates institutions. But in areas where it allows the Indian constitution full play, it is silent. It creates its institutions. It is, my lord, an additional act of affirmation. But that is what our Constituent Assembly did, my lord. Imagine, my lord, our Constituent Assembly in its wisdom gave space, gave a certain sense of choice to people to determine. My lord, I think nothing could have been greater than that. And likewise, the response of the people of Jammu and Kashmir in their Constituent Assembly, they matched it. They have matched it with the words of this constitution. And, my lord, this constitution is also a parchment of pride, my lord. It defines them. It defines their persona. And they are not saying anything else. They're saying it cannot demise. A constitution, my lord, cannot demise. A constitution, my lord, cannot evaporate or eviscerate. Unless, my lord, it is done in a manner known to law. So, my lord, sub-article 3 of Article 370 worked itself out. It was meant to be acted on. They acted on.
You see, Subramaniam. Yes, Mr.
Yes.
Subramaniam.
My Lord, I wanted to point out, my Lord, they even kept out of their amending power in section 147 of the Constitution at PDF page 85. Your Lordships will notice section 3, 5 and the provisions of the Constitution of India as applicable, they will never touch. My Lord, I don't think the resolve of people is clearer than this. The resolve of a Constituent Assembly cannot be clearer than this. That they celebrate the unity of India and they say, we will never touch it, will not amend.
Mr. Gopal
Section
Subramaniam,
3.
on one aspect, there is no less at all, is as far as integration into
Yes.
the India is concerned, there is, I don't think any of the sides are at item. So that we accept, that's a foundation on which we have proceeded.
Yes.
And then the issue has arisen with regard to Article 370.
Yes.
The recognition
right.
of the Constitution of J&K will be also, or Constitution of India as applicable to J&K,
That's right.
dedicated and from on the basis of Article 370.
That's right, my Lord. So now we look at the other two points about the validity of these two actions. Once, my Lord, we are clear that the provisions of the Constitution of India as applicable in relation to the state can never be changed, my Lord, this is called an acknowledgement in a constitution. It's a total acknowledgement of the Constitution. And, my Lord, the question which arises for your Lordship's consideration is, if the Constituent Assembly of Jammu and Kashmir and the Jammu and Kashmir Constitution paid such and accorded such supremacy to the Constitution of India, we are now, my Lord, coming to the question which Justice Khanna posed, what about the powers under 370? We're coming straight to the point, my Lord. What about the powers under 370? My Lords, I am not looking at the inconsistencies in the government of India's pleading. I will assume that they can argue anything as long as they can show power and its valid exercise. Let me assume that they can raise any argument, but let them show where is the power and where is the exercise. Now, my Lord, let's start with the first. It was suggested that Article 367 was a route. The amendment of Article 367 was a route because we have done it in the past. We have done it once more. Very simplistically put. But, my Lord, when was it done? It was done, my Lord, in 1954, in CO 48. It was done in 1958, in CO 56. And it was done a third time, my Lord, in 1965, in CO 74. Now, my Lord, your Lordships will be a trifle surprised to know that the modifications to Article 367 in CO 48 and 56, 48, my Lord, is at volume D3, page 13, and CO 56 is volume D3, page 25.
Page?
My Lord, they provided these two orders when it amended Article 367.
D313 and D325.
Yes, D3, page 13, my Lord, and D3, page 25.
Okay.
And if your Lordship sees it, My lord, Article 367 was to provide for definition for terms which appear in the order. Please look at it for a moment.
25. That point you made, Mr. Subramaniam?
My lord, that is the amendment proposed in 367 was to define terms in the presidential order. The first two. If your lordship sees 13, my lord, for a moment, I can just demonstrate it straight away. Please come to page 13, my lord, it starts. Please come to 18.
Yes.
For the purposes of this constitution as it applies in relation to the state of Jammu and Kashmir, references to this constitution or to the provisions thereof shall be construed as references to the constitution or the provisions thereof as applied in relation to the said state. And your lordships will find references to a high court shall include references to the High Court of Jammu and Kashmir. Reference to the legislature of a legislative assembly shall be construed as including references to the Constituent Assembly of the said state. And, my lord, likewise, the 58th order. CO 74 of 1965, my lord, please take the dates. It's a little important. The 1965 order was preceded, my lord, by the J&K Amendment, Constitution Amendment Act.
Was preceded by?
It was preceded, my lord, by the Constitution Amendment Act of 1965. My lord, that was enacted on 10th of April 1965. Sixth Amendment Act. And, my lord, the CO 74 in Damnu's case was issued on 24/11/1965. Now, my lord, we come to the question about the power under 370. My lord, any power under the Constitution, my lord, is not untrammeled because we have a controlled Constitution. We have to see whether the power is exercised for the purpose for which it was conferred. And if that purpose, my lord, implies, as my lord the Chief Justice perspicaciously pointed out, either consultation or concurrence, or, my lord, in a one-time decision, a decision of the Constituent Assembly, it is very clear that Article 370 itself negates unilateralism. It actually is widely worded, but it still, my lord, involves the state, it involves the legislature, it involves the Constituent Assembly. Mr. Sybil, my lord, is perfectly right when he says that those who have actually lived by the sword of the proviso and have taken recourse to Article 367, they must actually be tested on that basis. But, my lord, I am going to deal with the argument fully. But I'm going to put it in very simple words. First was, you can ignore the proviso. Second was, what is this word recommendation? It's a recommendation. You are the ultimate. You're the president. But my lord, recommendation of a Constituent Assembly in a context in which that word is placed in sub-article 3, my lord, tells us that it is a condition precedent. Gopalaswamy Iyengar definitely called it a condition precedent, but my lord, on principles of constitutional construction, you would be justified in interpreting it as a condition precedent, which means, my lord, if that condition precedent was not satisfied, the power was unavailable. This is not a normal proviso. And my lord, marginal notes with great respect. After Keshavananda Bharati, all the learned judges said it doesn't control a constitutional provision. But I'm starting, my lord. Yes, we thought it was temporal. But by the will of people, it became a mainstay. Now, my lord, there was also a suggestion. There is a power coupled with a duty to abrogate Article 370 because of this marginal note. My lord, power coupled with a duty can sometimes be implied, but here it is a self-contained code, Article 370. The duties lie within Article 370. The assumption of a duty, my lord, outside the Constitution is never permissible.
Mr. Subramaniam, I think we have given you sufficient time in a rejoinder now.
Yes, my lord, I'm quickly galloping.
Yes.
My lord, I can't look galloping, but I'm galloping. I'm galloping, my lord. I wouldn't necessarily, my lord, inflict on you a little more than needed. No. My lord, I'm only referring to the nature of the arguments with reference to marginal notes, with reference to the proviso, and I'm saying, my lord, that they are completely untenable. But, my lord, there is also something which must be brought to your lordship's notice. There was this 1952 agreement. We all had a summary. We were looking for something more authentic. Then my Lord Justice Gavai rightly said that, well, it has at least been introduced by the Prime Minister of Jammu and Kashmir in the Constituent Assembly. But look, this was also introduced by the Prime Minister in Parliament, the 52 agreement. And your lordships, I'm just giving the pages only the pages. It is in volume D9. The relevant pages are 53, 54, D9. These are parliamentary debates, 53, 54, 55, and 96. Now, my lord, I come to Parathe's case.
These are the parliamentary debates on?
On, my lord, the 1952 agreement. There was a motion. It was brought to the House, my lord. It was discussed before Parliament. And of course, my lord, it's a pretty long speech, but the Prime Minister spoke about this agreement, and they seemed broadly an item with what Prime Minister of Jammu and Kashmir said. Now, my lord, we come to 2 points, and I'm finished. Article 3, Babulal Parathe. My lord, Babulal Parathe's case is distinguishable. That, my lord, is to be found in Case Law Compilation 6 at page 124.
124.
Yes. And what is significant, my lord, is Justice Das says in our Article 3, we do not have a similar provision like the corresponding article in the American Constitution that the consent of a state legislature is necessary. This is very important, my lord. This is what Justice Das observes correctly. And now, my lord, if you see the 1954 order and the proviso to Article 3, it is precisely that provision in the American Constitution.
You are at page?
Page, my lord, 121 at 124 in volume C6. And then, my lord, I now deal with one point quickly, which is privy purses. My lords, there is no analogy between privy purses in this case. Privy purses, my lord, is a case of ex-rulers. Here, my lord, sovereignty passed on to the people in Jammu and Kashmir already. And even the judgment, which has been relied upon very heavily, my lord, which is Raghunath Ganpat Rao's case in volume C7, 537 at 562, my lord, Justice Pandian speaks glowingly about one basic feature of the Constitution called political justice, political rights. Political justice and political rights, Justice Pandian says, has not been touched by the Constitution 26th Amendment. Well, on that very passage, I rely upon to say, in our case, what we are dealing with, my lord, is not only the Constitution, we are also dealing with the class of rights which have been guaranteed to people in Jammu and Kashmir, both under the Indian Constitution and the Jammu and Kashmir Constitution. I would therefore, my lord, respectfully submit that the outcomes of integration, my lord, have been achieved. We may have different perspectives on it, my lord, but we are now only dealing with the validity. And my lord, 356, with very great respect, my lord, is never intended to use for the purpose of usurping state legislatures as bodies ea nomine by Parliament. No, my lord, it cannot be done. That notional vesting of power, my lord, is limited for a small purpose under 356. 370, my lord, is not a purpose which is intra-vires 356. It is alien to 356. And in any event, my lord, 370 says, notwithstanding anything contained in the Constitution, which gives it a certain degree of immunity. My lords, any questions? I'm ready.
Thank you. Thank you, Mr. Subramanian. Thank you very much.
You.
Mrs. Zafisha?
Wait, please, Your Lordship.
It's a pleasure to hear, my lords, the counsels on both sides on various controversial issues which have arisen in the case. What I see is that several issues have been raised in this matter, and the court ultimately is to decide whether this CO 272 and 273, whether they're constitutionally valid or invalid. That would be the direction of the court, and that would be the ultimate decision of this court, whether they need to be sustained or quashed. While making the submissions, lords, the councils have made at a different level of abstraction as to what possibly could be the grounds on which these two orders can be quashed. My approach would be to go on more fundamentals, the basics of it. The first premises, which to my mind is extremely important, is the existence of the state of Jammu and Kashmir at one point of time in history, and the formation of the Union of India at the same time in history. While as India was being unionized, Jammu and Kashmir state by itself was not a part of India, neither it was a part of British India. Now we have it clear from the various statutes itself, whether it's Government of India Act or whether it's Indian Independence Act, that state of Jammu and Kashmir not being a part of the Union of India at that point of time, nor was a part of British India. It was altogether an independent state. It had its own king, it had its own country, and it had its own laws. The king at that point of time would run the affairs like any other king of any other princely state would do. And the king of the state of Jammu and Kashmir, I will not go back too much in the history, also had certain laws which governed the running of the government. Either the state subject definition, which was introduced way back in 1927 and 1932, which applied only to the people who were residing in that state. Or from time to time, as has happened in all countries of the world, there have been changes, democratization has taken place, and ultimately the Constitution Act of 1939 was also promulgated by that king. And he created certain institutions in them, supposed to be democratic, but at the same time, he retained all the sovereign powers with him. This was the situation with us. Now, when instrument of accession executed, the circumstance in which it was executed have been already said. They are evident from the letter of 26th October 1947. What is the nature of that instrument of accession has already been read. What was retained and what was transferred or donated to the Union of India. And the subsequent letter of the Governor General dated 27th of November 1947 has also been read, saying that we'll put it to the people of the state whether this instrument of accession is acceptable to them or not. These are facts of history. Having said that, thereafter, after 26th of October 1947 till 26th of January 1950, we have no other document evidencing as to the relationship of the state with the Union, except this instrument of accession. What was sought to be stated by the respondents was that there was this proclamation of 25th of November 1949. The Constitution of India itself was adopted on 26th of November 1949, a day before. That has also been read today morning, and it was read earlier also. It said nothing except that the Constitution of India, as may be applicable to the state, would be acceptable to us. At that point of time, it was the successor of the king who was in chair, holding the position of the Maharaja. So when the Constitution itself was being debated, that's again historical fact, what happened in the Constituent Assembly, who said what, may not be relevant, but ultimately the decision of the Constituent Assembly was this, that they to have Article 370 for state of Jammu and Kashmir. To me, this decision appears to be the most significant and important because it answers several other questions. Why for Jammu and Kashmir? Why can't we remove it today in 2023? What is so great about Jammu and Kashmir? If it is a part of India, why should it have a separate constitution? Why should it have a separate flag? Why should the President of India have to concur or consult in the matter of application of laws? These questions are answered by the Constituent Assembly itself, by the debates of the Constituent Assembly itself, and by the very existence of Article 370 as well as very existence of the Constitution of Jammu and Kashmir. Now, this is a fact of history. None of us can alter this fact of history. That is, in my opinion, the premises of this case. And as we proceed further, we find that this basic premise has continued over the years. Now, it's a separate question whether it can be done away with. And if so, in what method, by what procedures, by what process? That's a separate question altogether. The first is, as I would submit for Lordship's consideration, this fundamental premise that the state of Jammu and Kashmir was different, Union of India was different. They agreed to join hands, but on certain conditions, which conditions came to be incorporated in terms of initial instrument accession, set later on by the Constitution of Jammu and Kashmir, as well as by the Constitution of India. Now, well, there was another factor, that was the matter went to United Nations and resolutions were passed. Those are also parts of your Lordship's Constituent Assembly debates. Well, these matters were pending. The issue is this, that state of Jammu and Kashmir and Union of India agree so far as the integration. When I'm using this word integration, I mean in the sense of Article 1 of the Constitution of India, as well as Section 3 of the state of Jammu and Kashmir. While that stays, but I, the state of Jammu and Kashmir, should have the power to regulate my own affairs, accept what I have given to you. This is what I'm conditioned to that. So in instrument accession, I gave you something. I gave you defense, foreign affairs, and communication. I gave it to you, make laws for it. But for remaining, I will make my own laws. Now, this was the position in 1950. If I put it differently, I had the ocean of, now later on today we call it now constitutional autonomy. Ocean of autonomy available to me in 1950. This is also a fact of history and an important premise in this case, that this position is accepted both by the Union of India as well as by the people of Jammu and Kashmir. I would also like to say something.
I just wanted to point out, look, we have referred to the history, we have looked at the
I was
concept
saying
points.
the premises only.
But the fact of the matter is, ultimately, when the constitutional document is drafted and adopted and applied by the people of India, and we, the people of India, include the people of J&K, they're not separate from them.
Yes.
We are part, they will be obviously in people of India, there will be people from Punjab, there will be people from Gujarat, there will be people from J&K. Now, the only issue that may not really be, because we have moved with the passage of time, we have to move with the passage of time.
We have moved. That's what I'm saying.
We
I'm
have
coming to
moved.
that. Yes, I understand.
And
My
now
lord's
the
anxiety,
question today is,
whether-
really speaking, is the second part, which is Article 370, which is the main constitutional challenge before us. So let's confine ourselves to that.
It's a question of how the court is viewing the matter. Firstly, we are viewing the matter in a historical perspective, which becomes the foundation of this relationship between union and the state. Well, later on, over these 69 years, have this relationship moved closer? Has this relationship moved forward? And whether there is any possibility in 2019 that we could have done away with the relationship in a sense that Article 370 would go, Constitutional Jammu and Kashmir would go. Have we reached that stage or not? That I will indicate a lot.
We'll continue after lunch, but at lunchtime, the remaining council may please ration out time so that we are done by 4 o'clock this evening. No further now rejoinders, please.